Hello, my dear students. We are studying Industrial Disputes Act 1947 under level of first paper. And today, under this act, Industrial Disputes Act 1947, we will discuss the other two bodies given under adjudication machinery. Industrial Tribunal given under Section 7A and National Tribunal given under Section 7B. This is video lecture number 26, my dear students. Industrial Tribunal, which is given under Section 7A of Industrial Disputes Act 1947. Like a labor court, an industrial tribunal is also a one-man body. The matters which fall within the jurisdiction of industrial tribunals are as mentioned in the second schedule or the third schedule of the Act. Obviously, industrial tribunals have wider jurisdiction than the labor courts. So, like labor court, industrial tribunal is also having or is also a one-man body, and the matters which fall within the jurisdiction of the industrial tribunals are as mentioned in the second schedule or in the third schedule of the Act. Obviously, industrial tribunals have wider jurisdiction than the labor courts. Moreover, an industrial tribunal, in addition to the presiding officer, can have two assessors to advise him in the proceedings. The appropriate government is empowered to appoint these assessors. So, in case of industrial tribunal, in addition to the presiding officer, there may be two assessors to advise the presiding officer in the proceeding, and the appropriate government is empowered to appoint these assessors. While, my dear students, when we were studying the labor code under Section 7, we have seen that there was only one presiding officer. While in case of industrial tribunal, there will be one presiding officer, but these industrial tribunals can have two assessors to advise him in proceedings, and these assessors will be appointed by the appropriate government. The appropriate government, by notification in the official gazette, constitute one or more industrial tribunals for the adjudication of industrial disputes relating to any matter, whether specified in the second schedule or the third schedule, and for performing such other functions as may be assigned to them under this Act. So, my dear students, the appropriate government, through a notification in the official gazette, constitute one or more industrial tribunals for the adjudication of industrial dispute relating to any matter, whether specified in the second schedule or the third schedule. My dear students, you may recall that when we were studying the labor code, under the jurisdiction of the labor code was given under the second schedule, or the matters which are given under the second schedule of the Act, only those matters can be referred to the labor code. While in case of industrial tribunal, the matters which are specified in the second schedule or the third schedule may be referred to the industrial tribunal. A tribunal shall consist of one person only, to be appointed by the appropriate government. A person shall not be qualified for appointment as the presiding officer of a tribunal unless So my dear students, here we are talking about the qualification part, that what is the qualification and when a person can be appointed as a presiding officer of an industrial tribunal. So a person shall not be qualified for appointment as the presiding officer of a tribunal unless he is or has been a judge of the high court, or he has for a period of not less than 3 years been a district judge or an additional district judge. The appropriate government, if it so things fit, appoint 2 persons as assessors, as I have already told you, to advise the tribunal in the proceedings before it. And industrial tribunal may be referred the following issues. So my dear students, now we are talking about that what matters may be referred to the industrial tribunals. So the matters which are related to the wages, including the period of the wages and the mode of payment. So if there is any dispute which is related to the wage period, and which is, or if there is another matter which is related to the mode of payment, then these kind of matters may be referred to the industrial tribunals. Compensatory and other allowances. If the matter is related to the compensatory or the other allowances, then these matters may also be referred to the industrial tribunals. If the matter is related to the hours of work, or the matter is related to the working hours, or related to the rest intervals, then these matters may also be referred to the industrial tribunals. Another matters which may be referred to the industrial tribunals are leave with wages and holidays. So if there is any dispute regarding leaves with wages and holidays, then these matters may also be referred to the industrial tribunal. If the matter is related with bonus, profit sharing, provident fund, and gratuity, then these matters may also be referred to the industrial tribunals, and industrial tribunals may decide these matters also. If any matter is related with the working shift, otherwise than in accordance with the standing orders. So matter which is related with the shift working, otherwise than in accordance with the standing orders, then these matter may also be referred to the industrial tribunal. Rule, if the matter is related with rule of discipline, or it is related with rationalization, or if any matter which is related with in retrenchment of the workman, then all those matters may also be referred to the industrial tribunals, and any other matter that may be prescribed. So if there is any other matter which may be prescribed for the reference to the industrial tribunals, then these matters may also be referred to the industrial tribunal. So this is all about the industrial tribunal, my dear students. Now we will just discuss about the national tribunal also, which is given under section 7B of the Industrial Dispute Act 1947. As I told you that so far the labor court and industrial tribunal is concerned, then these two bodies may be taken care of by the state government and the central government also, but the national tribunal will be taken care of by the central government only, and the central government may constitute a national tribunal for adjudication of disputes as mentioned in the second and third schedules of the act, or any other matter not mentioned therein, provided in its opinion the industrial disputes involves a questions of national importance, or the industrial dispute is of such a nature that undertaking established in more than one state are likely to be affected by such a dispute, my dear students. So, so far the national tribunal is concerned, the central government may constitute this national tribunal, and for adjudication purpose, and disputes as mentioned in the second schedule and the third schedule of the act are, or any other matter not mentioned therein, provided in its opinion the industrial dispute involves the question of national importance, and the industrial dispute is of such a nature that undertaking established in more than one state are likely to be affected by such a dispute, then these matters may also be referred to the national tribunal. And the central government may appoint two assessors to assess the national tribunal. The award of the tribunal is to be submitted to the central government, which has the power to modify or reject it if it considers it necessary in public interest. So, my dear students, the central government may appoint two assessors to assess the national tribunal, and the award of the tribunal is to be submitted to the central government, which has the power to modify or reject it, and if it considers it is necessary in the public interest, then appropriate central government may do so. And it should be noted that every award of a labor court, industrial tribunal, or national tribunal must be published by the appropriate government within 30 days from the date of its receipt. So I repeat, my dear students, that it should be noted that every award of a labor court, industrial tribunal, or a national tribunal must be published by the appropriate government within 30 days from the date of its receipt. And unless declared otherwise by the appropriate government, every award shall come into force on the expiry of 30 days from the date of its publication and shall remain in operation for a period of 1 year thereafter. And my dear student, as I told you that the central government through notification in the official gazette constitute this national tribunal, where one or more national and industrial tribunals for the adjudication of industrial disputes. And if there is the central government is having this opinion that the matter is related to the, or where the question of national importance is there in the matter, or the nature of that industrial establishment situated in more than one state are likely to be affected and interested in such disputes, then these matters may be referred to the national tribunal, as I told you, and national tribunal shall consist of one person only to be appointed by the central government, and there may be other assessors also to help those presiding officers there, and a person shall be qualified for appointment as the presiding officer of a national tribunal unless he is or has been a judge of the high court. And the central government may, if it thinks fit, appoint two persons as assessors to advise the national tribunal in the proceedings before it. So usually the central government may, by notification in the official gazette, uh, constitute one or more national tribunals for the adjudication of industrial disputes. The what matters will be referred to the national tribunal: national matters, or the matters in which industries are more than one state or are affected by the outcome of the dispute. The duty of the national tribunal to hold its proceedings fast and submit its reports to the central government within a specified time given. So this is the duty of the national tribunal, uh, to hold its proceedings fast and submit its reports to the central government within the specified time given. And Section 15 of the Industrial Dispute Act 1947 talks about the duties of labor courts, tribunals, and the national tribunals, where an industrial dispute, and the duty is given under section 15, that where an industrial dispute has been referred to a labor court, tribunal, or the national tribunal, then for adjudication, then it shall hold its proceedings expeditiously and shall within the period specified in the order referring such industrial dispute, or the further period may also be extended under the second proviso to subsection 2A of section 10, submit its award to the appropriate government. So, my dear student, this is about the section 15, where the certain duties on labor courts, tribunals, and the national tribunals. There are certain disqualifications for the presiding officer of the labor courts, tribunals, and the national tribunals under section 7C Industrial Dispute Act 1947, that no person shall be appointed or continue in the office of the presiding officer of a labor court, tribunal, or a national tribunal if he is uh, not an independent person. So if the person is not an independent person, then person can, cannot be appointed or will not continue in the office of the presiding officer of a labor court, tribunal, or a national tribunal. And the other disqualification is if the person has attained the age of 65 years. If the person has attained the age of 65 years, then he will not be appointed and will not continue in the office of the presiding officer of a labor court, tribunal, or the national tribunal. So these are certain disqualifications for the presiding officers of the labor court, tribunal, or the national tribunal, my dear student. So this is all for today's lecture, my dear students. Thank you so much. I believe today's lecture will give you an insight about the adjudication machinery, where we have just gone through today the industrial tribunal section 7A, the national tribunal under section 7B, what matters may be referred to the industrial tribunal that we have seen, what matters may be referred to the national tribunal that we have seen, and what are the qualifications to be appointed as a presiding officer of the industrial tribunal and as well as to the national tribunal, and what would be the disqualifications for the presiding officers of labor courts, tribunals, and the national tribunals. So this is what we have covered today, my dear students. I hope that today's lecture will give you an insight about the adjudication machinery and will uh, resolve your doubts. Thank you so much. And in our next lecture, we will take up some new topic under Industrial Disputes Act 1947. Thank you, my dear students, and have a nice day. Have a nice time. Thank you so much.